Let's have the next question, please, guys. Let me put the next questions on the board. Thank you. Okay. Yep. If a deportation order has already been issued against me, what options do I have to reopen or fight my case and remain in the United States? Very good question. Because sometimes an order issued against you is not necessarily the end of the world. So yes, even after a deportation order has been issued, it may still be possible to challenge, to reopen, or delay the order depending on your circumstances. However, these options are limited. They are time sensitive and they are highly dependent on legal eligibility. Again, this is another area where you absolutely need a qualified lawyer to be able to walk you through it once you get a deportation order. See, a deportation order means an immigration judge or authority in the US has already decided that you are removable from the United States. At this stage, the case is considered closed. You need to get this. At this stage, the case is considered closed unless a legal action is taken to reopen or challenge that decision. So you need to understand that a final order does not always mean all options are permanently gone. So one of the main legal options you have is filing a motion to reopen or what we call a motion to reconsider. A motion to reopen is typically used based on new evidence. Maybe you have a new situation, or maybe you recently got married, or you have a changed circumstance that were not available during the original hearing. So you can ask your lawyer to do a motion to reopen for you. A motion to reconsider is a little bit different. And that one is arguing that the original decision that is involved is as legal or procedural errors. In other words, a motion to reconsider is trying to tell the judge that he needs to reconsider his decision because he made a mistake or because he applied the wrong law. That is different from motion to reopen, which is based on changed circumstance or new evidence. Sometimes people mix those two up, even lawyers, but they're very different things. The one important thing here, though, is that these motions, either of them, must be generally filed within strict deadlines. Typically, it's 30 days. Though exceptions may exist in special situations, like, for instance, the one that is very common, ineffective assistance of counsel or exceptional circumstance. Because if somebody has been ordered deported 2 years ago, 3 years ago, obviously, he didn't file a motion to reopen. He didn't file a motion to reconsider within 30 days, but there are some exceptions to that 30-day requirement. If, for instance, another lawyer has looked at your case or you look at your case and you felt that the lawyer who did it made a mistake, then you can ask the judge to reopen your case based on ineffective assistance of counsel, even if it has been over 1 year or 2 years or 3 years or even 5 years that the judge has made that decision. So that's one of the exceptions to the 30-day. You see a lot of this happening now. Is why a lot of lawyers like to protect themselves, because a lot of immigrants are using that loophole. They were deported 5 years ago, but they don't want to go. Now they want to figure out a way to reopen their case. They fabricate story against their lawyer and say their lawyer messed up. And then, based on that, they will reopen the case. Before, it didn't used to be a big problem. Most of us in immigration law, we see it as a matter of course, we don't care. The important thing, we know that this person doesn't have anything against me, but he's just trying to reopen their case. But it's getting more serious now because the bar is not disciplining the lawyers. Before, when you file a motion for ineffective assistance of counsel, nobody does anything to the lawyer. As long as you can explain the mistake the lawyer did, and then maybe you file a bar complaint. Typically, the bar complaint will just ask the lawyer to explain. He will explain himself and they dismiss it. and then the judge reopens your case. But now, bar associations are taking it more serious. And people are losing their licenses because somebody filed ineffective assistance of counsel against them just to reopen their case. So every lawyer is now being more careful. Don't leave room for one desperate immigrant to then take your license away, because when it comes to immigration, it's a very emotional thing. Nobody wants to go home. So if they have to throw their lawyer under the bus, they do it. It is for the lawyers to not put themselves in a position that they can be thrown under the bus. So coming back to your question, a deportation order is serious, but it's not always the final in practice. They are limited but important legal pathways, such as motions to reopen, filing an appeal, stay of removal, ineffective assistance of counsel, or a new application for relief that you can use to sidestep that without actually going to your country. However, success depends on timing, eligibility, and strong appeal arguments. And this makes professional legal assistance very essential. In today's immigration, I tell people, they think, oh, he's trying to market for business. I tell them, don't do anything without talking to a lawyer. If you can't even afford the big money to hire them fully, at least go for consultation. Pay them their consultation fee, $200, $250, whatever. Go there, spend an hour asking all the questions you need to know about your case. And then if you now still want to continue to do it by yourself, at least you will have gotten legal advice in that 1 hour that will help you understand your issues. I hope you get that, and I hope that was helpful to you. I'm a friend. All right, Grace, put up this next question for me, please. Let's see where we are. And thank you so much for those of you who are joining us from home. If you are enjoying this, give us a good emoji in the chat wherever you are watching this from. I know we are probably live on Instagram, we are live on LinkedIn, we are live on YouTube, and I think on Facebook. Hopefully you can hear me well. We are not able to see many of your comments in the chats, but we are working on that. This is Immigrant Survivor Show with Ope Banwo. And if you have not yet subscribed to our free weekly bulletin, please, you want to go over there right now and you want to join banwolaw.net/newsletter. Okay. And if you are watching us now and you would like to consult with me, it is let me put that on say, and you would like to talk to me about your specific immigration case, you want to go to speakwithope.com. Speak, I'm trying to type that on screen for you. I'm waiting for Grace to put in the next question. Speakwithope.com. Okay. Yep. For consultation, it's very simple. Speakwithope.com. And I'll be more than happy to discuss the nuances of your specific case, to do a one-on-one discussion with you. And just go in there and book. Hopefully, you are going to get time on my calendar. The calendar is getting overbooked so fast these days, but go check it out. Hopefully, you'll be able to get a date.